All right, welcome back. I hope everyone had a good Christmas and your food comas are over and you got everything you wanted. Santa Claus treated you well. So, we're back for another fun filled episode with plenty more examples that Delete Lawz is incapable of learning. He's incapable. He I mean, the the common definition of insanity, doing the same thing over and over and expecting different results. That's him. That's him. He cannot learn. He does the same thing over and over, and he's absolutely shocked that nothing changes, that the judges don't buy it. Because if you're wrong in court over and over and over, the judges are going to rule against you. It's that easy. That easy. So, for those of you who are new here, hi, I'm Joe. I'm an attorney licensed to practice in the state of Utah. This is DeCastro versus the Las Vegas Metropolitan Police Department. Las Vegas being Las Vegas, Nevada, not Las Vegas, New Mexico, or any other Las Vegas there might be. Um, so basically, scrolling down the docket, last time we were here, we looked at LVMPD's motion to dismiss the second amended complaint. That was our primary focus, at least, and boy, that took a long time to get through. So our main focus today is going to be Delete Lawz motion to strike the motion to dismiss, or in the alternative, for an extension of time to file an opposition. Basically, Schnookums is just too busy because he's got an appellate brief due in DeCastro versus Wagner in the Sixth Circuit. That's the Ironton case. And he's just too busy preparing for that to get things done in time here. But do you know what lawyers call that? Lawyers call that malpractice. I know, shocking, right? Only problem is you can't commit malpractice against yourself. But lawyers have an ethical duty to competently represent their clients. And part of that is getting things done on time. And if they don't have the ability to handle things on time because their caseload is too large, they have an ethical duty to, hand off a case, to hire help, to do something. I'm too busy is not an excuse to be late. But we'll see. As of now, he is late, unless the judge actually does grant him an extension, which they shouldn't. They shouldn't. He doesn't have a good excuse. And I realize it was pointed out to me, I said due Christmas. Technically, it was due Christmas, but I always forget he plays things from both sides. And so he asks for access to ECF, but then doesn't sign up for ECF, at least in this case. So I forget he gets a few extra days for mail time. So as of now, though, unless it's in, it's late. And so we're going to do that. And then we're going to discuss a discovery issue, which wasn't actually an issue. It's just, once again, Delete Lawz not knowing the rules. Delete Lawz wanting to have it his way, whether he's allowed to or not. and throwing a tantrum if he doesn't get things his way. And the judge has already ruled against him on that. Surprise, surprise. I realize, spoiler, but we'll get to that at the end. And the first thing we have to do, though, first things first, is we need to go back a week. Well, 2 weeks, I guess. 2 weeks today, since it's past midnight now, recording this. And I hate to do this one, but we do need to do docket number 69. Nice. I'm legally required to say nice after saying 69. Nice. But we need to do that because that's a notice of change of address by Delete Lawz. Why do I hate doing that? Because I don't want to be accused of doxing him. Now, his address, it's public record. It's in court filings. I'm not doxing him. I don't like putting it on screen, though. You'll notice I generally start the documents below the addresses in the caption. There's a reason I do that. But unfortunately, he has made his address an issue. So we need to look at that, which is a good time for the general reminder, but let's change it up a little bit. We still are not a petting zoo. We're on safari up in Yellowstone. You do not pet the bison. You give them their space. You do not shout at them. You do not address them. You look from your car. Got it? Good. So with that, let's take a look. So the plaintiff's notice of change of address, the address caption still lists Santa Monica as his address, Santa Monica, California. But take notice, effective December 1st, 20. Okay, December 1, 20. The mailing address for plaintiff has changed to Las Vegas, Nevada. This is a UPS store, I believe. And it's way too close to for comfort to my sister's old house from when she lived in Las Vegas. But like, we're talking walking distance. But luckily, she's not there anymore. She's near me. So that's important, though, for reasons you'll see in the next couple documents, especially the discovery dispute. But it's also important in this document, the motion to strike, defendant's motion to dismiss, or in the alternative, for an extension of time to file an opposition. Now, well, actually, we need to scroll up. You'll notice, once again, Santa Monica, California in the caption. So he filed the change of address, but even still, 2 weeks later, this is captioned Santa Monica. Where do you live? Where do you live, Jose de Castro? Where do you want your documents sent? Where do you want discovery sent? You can't leave it ambiguous and then complain when Craig Anderson sends it to the wrong one when you kind of seem to want it both ways. You're just playing games, and that's not right. And I should point out also in the caption, the title, he is pleading this in the alternative. We've seen that many times. The The motion to dismiss was pled in the alternative. Motion to dismiss, or in the alternative, motion for summary judgment in favor of LVMPD. So Delete Lawz should know what pleading in the alternative is. He's doing it here. But in his argument below, he doesn't. He needs clarification because he's dumb. So, Plaintiff Jose de Castro, plaintiff, respectfully moves this court to strike defendant's motion to dismiss plaintiff's second amended complaint or for summary judgment at ECF number 66 in full, as it raises arguments and alleged facts without proper verification. Additionally, defendants could have raised these arguments in their original response, but omitted them. Defendants have already filed an answer. Plaintiff's amended complaint has not substantially changed in legal argument and facts, but rather the amended complaint clarified what apparently sounded like conclusions of law to this court, but which were not. Is he serious? They sounded like conclusions of law to the court, but they were not. You don't earn the title Captain Conclusory by twiddling your thumbs. When every single person says that's conclusory, except for you, you're wrong. Maybe, just maybe, Delete Lawz needs to go to the sovereign citizen favorite Black's Law Dictionary and look up conclusory. In fact, let's look up conclusory definition in law. In Merriam-Webster's dictionary, consisting of or relating to a conclusion or assertion for which no supporting evidence is offered. Recent examples on the web. Officials have to demonstrate specific harm that would come from release of specific documents, rather than broad, conclusory allegations. On all these legal questions, Cannon's consideration of these issues was superficial and conclusory. Plaintiff's allegations of racial animus are nothing more than conclusory, speculative assumptions apparently premised upon hearsay statements by unknown and unknowable actors. So that's Merriam-Webster's definition of conclusory. Let's see. Find law. Conclusory. Well, that just gives us the Merriam-Webster definition. Collins Dictionary. Coming to a conclusion or decision. Conclusive. In law, asserted as a conclusion without supporting facts. Oh, hey, here's Black's Law Dictionary. So this one might hold a little weight for our little sovereign citizen friend, although I think he's sovereign citizen light. Okay, an inference that has no proof but is stated nonetheless. So Delete Lawz does not understand that when we say things are conclusory, him saying there was no probable cause, that's a conclusion of law. Him saying, they arrested me because of the color of my skin, because I'm of Jewish Colombian descent. Those are just conclusions. Where's the evidence to back that up? Me saying Santa Claus brought me great gifts. That's conclusory. Yes, I received some great gifts for Christmas, but I have no evidence that it was Santa Claus. In fact, the fact that I was with my mom shopping when she bought me an R2D2 Lego set to build with my niece and nephews. Well, that would lead to the conclusion that it was, in fact, not Santa Claus. So he just does not get that. And this sentence here, the amended complaint clarified what apparently sounded like conclusions of law to this court, but which were not. Boy, that snark is going to get you in trouble one of these days. You are not winning any favors. And when you accuse the court of extrajudicial bias against you, this isn't extrajudicial, and it is biasing the court against you. It is making the court like you less and less and less. But guess what? Guess what? You're not going to get the court to recuse itself. You're doing this in your own filing. It's your fault. In the alternative, plaintiff respectfully moves this court for an extension of time to file an opposition to the motion. Plaintiff needs another 30 days to respond to said motion, as he just yesterday received defendant's thumb drive containing multiple hours of video after they sent it to the wrong address, because he is currently working on an appellate brief in his Ohio case that is due in 1 week. The holidays are getting in the way. He is a pro se party, and plaintiff needs to know if this motion is being converted to a motion for summary judgment. Shall we go over each of those in turn? He needs 30 days. No. You wouldn't have, even if they had handed you the thumb drive on day one, and you were not working on an appellate brief, and you had an attorney, you know, everything is ideal conditions for you. No holidays in the way. In fact, I'm surprised he's not bitching about his criminal trial, which is within 30 days. Because that's another reason to ask for an excuse, just not really. But even if everything were perfect, all conditions were perfect, he received the thumb drive immediately. Guess what? Guess what? You wouldn't receive 30 days. So you saying you need 30 extra days, that's preposterous. That's preposterous. You 30 days to respond to a motion on top of the time he had to respond. That's insane. But the defendants sent it to the wrong address. They sent it to the wrong address. Well, once again, we don't know when it was sent, but let's just say it was sent the same day. Well, notice of manual filing. So it was probably filed or sent on or around December 12th. In fact, let's take a peek at that. So flash drive sent first class mail to Santa Monica, California. So, yeah, sent to Santa Monica, California. The wrong address. The wrong address. 1258 Franklin Street. It was sent to 1258 Franklin Street. It was sent to the address that is still on the caption of every single one of his filings. It was sent to the right address. You just don't monitor that address. Although I believe he had a falling out with the owner of that address, which I'm not sure if it's Condon or Lloyd. Either way, he had a falling out, I believe, and that is why he didn't receive it. But here's the thing. When you're engaged in litigation and you have the opposing party sending stuff to an out-of-state address that you don't monitor and you don't receive stuff from, that's your problem. It is your problem. It is not the other side's problem. If they knew you were living in Las Vegas, do you know what they would have done? They would have emailed you, come to the office and collect the thumb drive. Or where would you like our courier to drop the thumb drive this afternoon? But because you have a Santa Monica address, that's where they sent it. They're not going to send a bicycle messenger, a courier to Santa Monica. They're going to send it in the mail. He did his notice of change of address on December 15th. So after it was sent. How could they have sent it to the wrong address when they sent it to the address on file on the lawsuit? And he didn't even file the change of address until at least 3 days later. Riddle me that. So, currently working on an appellate brief in his Ohio case that is due in 1 week. Shall we take a peek? Let's take a peek. Okay, DeCastro versus Wagner, Sixth Circuit. So October 5th, the civil case docketed. Briefing letter setting pro se briefing schedule on November 21st. So he's got 1 week, but he has in reality had at least since the beginning of October to be working on it. Procrastination sucks, man. If you're involved in multiple cases of litigation, maybe don't procrastinate, because then you're going to run into this. And like I said, in the business, we call this malpractice. With a pro se, we call this an oopsie doodle. It's his fault. It's a self-inflicted wound, an own goal, a safety in the other football. It's your fault. Holidays are getting in the way. I mean, that could have been a little gamesmanship from Craig Anderson, like I said, but responding early. doing the motion to dismiss early. But guess what? That Christmas doesn't delay deadlines. The only way it delays a deadline is if the deadline is on Christmas and you have to file it manually. If court is closed. But guess what? Court opened the 26th of December and is open the rest of the week. It will be closed on Monday, January 1st for New Year's. And then it'll open again on the 2nd. So court's open. It's not an excuse. Your brief is due when it's due. Now, courts will give a lot of latitude for I'm busy for actual court appearances because you can only be in one place at a time. Now, Zoom has made it a whole lot easier, but if you're trying to schedule a hearing for it and the judge says, how does next week say? And, oh, sorry, I'm in trial all week. Well, that's going to take precedence. If you already have something in the calendar, they'll say, well, how about earlier that day? How about later that day? How about the next day? They'll make it work. But if you have a document due, a filing due, it's due, holiday or no. This is not good cause. He is a pro se party. We know. Once again, that's a shield, not a sword. He keeps trying to use it to go on the attack. But once again, pro se means the court should construe your pleadings liberally. If you get all the elements in, but it's inartfully pled, the court should construe it as being good enough. But as we have said, case law says, being pro se does not excuse you from following the rules to the letter. The due dates are procedural. They are rule-based. It's not a pleading error. It's a rule error. So once again, this is malpractice. This is an oopsie doodle. This is your fault. It's against you. And then finally, plaintiff needs to know if this motion is being converted to a motion for summary judgment. That's what pleading in the alternative is. I mean, let's go back up here. Should Craig Anderson respond and say, well, Judge, I can't respond to his last motion because I don't know if it's a motion to strike or if it's a motion for an extension of time. I don't understand what alternative pleading is, so you need to tell me which one it is, and then I'll respond to that. Delete Lawz pleads in the alternative here, but he doesn't understand what alternative pleading is here. What you do is you respond. Well, basically, you respond to the summary judgment. You respond to both. You say, based on the motion to dismiss standards, it should survive motion to dismiss because, and cite to the complaint, the second amended complaint, and then say, and it also survives the motion for summary judgment because the undisputed, there are disputed facts, basically, is what you'd say. But you don't wait for the court to say, well, I'm going to decide it based on this. No, the motion was brought for both. Sucks to be you. So, memorandum of points and authorities. Extension of time. Federal Rule of Civil Procedure 6B allows this court to extend the time of when a paper is due for good cause when the request is made before the original paper is due. Additionally, where good cause is shown, a request for an extension generally should be granted in the absence of bad faith by the moving party or prejudice to the adverse party. That's Ahanchian versus Xenon Pictures, Ninth Circuit 2010. Here, the paper is not yet due, and the plaintiff has good cause. So, looking back at the docket, this showed up on the docket on the 26th, 27th. Showed up on the 27th. It was, in the meantime, updated as having been received on the 22nd. So, just the same, I don't believe he's actually shown good cause. Like I said, malpractice is not good cause. Now, this is where it's fun. Defendants don't get another bite at the apple. So, plaintiff gets all the bites at the apple he wants. He gets the whole damn apple. But defendants only get to defend themselves once. And once they successfully defend themselves, and the court allows me to make changes, they don't get to defend against those changes. So, an amended complaint does not revive the right to file a post-answer motion to dismiss, with the exception that new claims may be attacked. That's citing Rosenblum versus Blackstone, which is an unpublished collection of cases from the Central District of California. We'll get back to that. See also Burton versus Ghosh, 7th Circuit 2020. So that's not binding case law. Here, defendants have filed an answer, have participated in discovery, and have attacked more than just the new claims. Have I mentioned recently how Delete Lawz doesn't understand case law? He cannot understand case law. He never understands case law. So this collection of cases, Rosenblum versus Blackstone, is unpublished. So I don't have it. I don't pay for LexisNexis, unfortunately. It's expensive. But Burton versus Ghosh, 7th Circuit, 2020. So, unsurprisingly, there's a very easy distinction to make in that. So, Burton versus Ghosh. Burton was an inmate in prison or jail, I can't remember. He sued over medical issues, and that was dismissed. He sued a different doctor, and they filed a motion to dismiss, and then he amended the complaint by adding more detail. He didn't change anything, he just added more detail. The claims stayed the same, everything else stayed the same, just with more detail. After that, the defendant realized, hey, wait, we didn't assert the affirmative defense of res judicata, meaning, hey, wait, a court has already decided that his rights weren't violated. So this court needs to recognize that previous court's ruling that his rights were not violated and dismiss it against this defendant. And the court did. Burton appealed, and the Seventh Circuit said, you know what? No, you didn't do that on your, you have to raise your affirmative defenses in your first responsive pleading. So you need to do them in your answer. And you waived this by not including it in your answer. Now, you'll say, but hang on. An amended complaint wipes the slate clean and you start over. And the court said, well, not completely. Not if nothing really changed with the amendment, if they just brought new details, but all of the claims are the same, all the causes of action are the same, all the parties are the same, yada, yada, yada. But you'll notice that's for an affirmative defense, not for a motion to dismiss. The filing of an amended complaint invalidates the previous motion to dismiss. It does not exist. It's vanished. So if they don't file a motion to dismiss, there is no operative motion to dismiss for the second amended complaint. How fast, if they don't file a motion to dismiss, is he filing a motion for a default judgment? They have to file a motion to dismiss. I mean, they could just go straight to an answer, or do you know what else they could go straight to? A motion for summary judgment. They can go straight to a motion for summary judgment. So even if the judge strikes the motion to dismiss, which they shouldn't, the court shouldn't strike the motion to dismiss because this motion is hot garbage. But even if they did, even if they said, you know what, Delete Lawz, you're right. They already had their chance to move to dismiss this second amended complaint before you filed the second amended complaint. You're right. They should have used their TARDIS. Now I'm going to rule on their motion for summary judgment. And you still lose. But once again, he has substantively changed his pleadings. He has brought new claims. He has brought new claims. He has brought claims that were dismissed with prejudice. So there's that. But he's also changed the way he has pled some of the other claims. So it's not just new details. It's not filling in blanks. It's completely changed. His story has changed. So there needs to be a new motion to dismiss. He just doesn't understand it. But his next argument, inauthentic evidence attached. Since the defendants offer evidence attached to a summary judgment motion, it must be admissible to be submitted. And that is true. Evidence needs to be admissible. And Federal Rule of Civil Procedure 56C. 56 is the summary judgment. Let's look at what C is. C, procedures. So need to worry about that. But either way, it can be inferred that the affiants are not competent to testify to the video being unedited or to its chain of custody, not being an expert or the defendant's records custodian. Affiants do not testify to who produced the documents and only provide conclusory statements as to their competency, and fail to properly support that assertion. It is more likely that these records were produced by a vendor or records custodian who refuses to testify under oath. The videos that defendants made available under Public Records Act requests were incomplete and are indicative of a credibility problem that calls the completeness of these videos into question. It is possible that what is available in defendants' exhibits contain incidents in this action, but it is unlikely that they are unedited or show anything relevant to or contradictive of plaintiff's testimony, nor is it the best evidence. Plaintiff's own recording of the incident, which is the only video referenced in the second amended complaint, is the best evidence, and defendants have not submitted it. Officers' recordings of what they might have said is not indicative of how or whether defendant heard it and is unrelated to defendant's actions. Here, defendant's evidence is neither the best evidence nor is it property authenticated and should be stricken. Once again, Delete Lawz does not understand the law. He does not understand the rules of evidence. He does not understand what conclusory statements are. Now, of the officers, let's was it in here? No, it's in the motion to dismiss. So this is what he's complaining about as conclusory. So this is Sergeant Torrey's declaration in support of the motion to dismiss. And it's, I, Sergeant Erland Torrey, hereby declare and say, I am over the age of 18 years of age and have personal knowledge of the facts stated herein, except for those stated upon information and belief, and as to those, I believe them to be true. I am competent to testify as to the facts stated herein in a court of law and will so testify if called upon. So Delete Lawz is saying, well, Sergeant Torrey's saying he's competent to testify. That's conclusory. Well, number one, that's basically a boilerplate part of the declaration. But the facts in evidence supporting that he is competent to testify is he is over the age of 18. He has personal knowledge of the facts stated herein. He will testify in court if he's called to testify. Those are facts indicating that he is competent to testify. So it's not conclusory. Even if it is boilerplate, it's not conclusory. And this declaration is brought to authenticate certain exhibits and court filings on behalf of the defendants in the case of Jose de Castro versus LVMPD. He's a sergeant. He has knowledge of the incident. He's reviewed his body-worn camera footage that is attached to the defendant's current motion. He can confirm that it is true, accurate, and complete. It has not been modified, edited, or otherwise changed. So Delete Lawz is complaining this declaration didn't come from the custodian of records. You're right. It came from someone better. It came from the author. It came from the videographer. It came from the person who made the video. He made the video. I mean, let's go back. So plaintiff's own recording of the incident, which is the only video referenced in the second amended complaint, is the best evidence, and defendants haven't submitted it. So, Delete Lawz, you haven't submitted it. You haven't. Do we have the custodian of records, the chief archivist at YouTube? Have they sworn that it's exactly how it was uploaded in the live stream? No. Because here's the thing. Here's the thing. Let's go to the federal rules of evidence. Because, like I said, he does not understand the federal rules of evidence, just like he doesn't understand the federal rules of civil procedure, just like he doesn't understand case law or statutory law. He just doesn't understand law. But hearsay. So, hearsay. Statement means a person's oral assertion, written assertion, or, and I said assertion, I meant assertion, or nonverbal conduct if the person intended it as an assertion. Declarant means the person who made the statement. Hearsay means a statement that the declarant does not make while testifying at the current trial or hearings, and the party offers in evidence to prove the truth of the matter asserted in the statement. So, the general definition of hearsay: an out-of-court statement made, offered for the proof of the matter asserted. So, statements that are not hearsay: a declarant witness's prior statement, an opposing party's statement, and we don't need those, because what we do need, well, we need the rule against hearsay. Hearsay is not admissible unless any of the following provides otherwise: a federal statute, these rules, or other rules prescribed by the Supreme Court. So, generally, hearsay is not permissible unless it is by some other rule. So, hearsay exceptions: declarant unavailable. So, a declarant is considered to be unavailable as a witness if the declarant is exempted from testifying about the subject matter of the declarant's statement because the court rules that a privilege applies. So, if there's attorney-client privilege, if there's priest-penitent privilege, if there's spousal privilege, you might be able to get their other out-of-court statements admitted under this exception to hearsay. If they refuse to testify about the subject matter despite a court order to do so, if they testify to not remembering the subject matter, so they can be refreshed by hearsay. They can't be present to testify at the trial or hearing because of death or then existing infirmity, physical illness, or mental illness. They're absent from the trial or hearing, and the statement's proponent has not been able, by process or other reasonable means, to procure their attendance. So, if they live out of state or more than, I believe, 100 miles, they can't be compelled to attend a trial. So, but there's exceptions. So, former testimony. So, if it was given in court or in a deposition or whatever and subject to cross-examination. statement upon the belief of imminent death. So if you make the statement believing you're about to die and then die, your statement can be admissible despite it being hearsay. Statement against interest. So if I say, well, Officer Tory didn't batter Delete Lawz balls, I did. And then I don't show up to testify. That, well, yeah. But statement of personal or family history. So the declarant's own birth, adoption, legitimacy, ancestry, marriage, divorce, relationship by blood, adoption, or marriage, or similar facts of personal or family history, even though the declarant had no way of acquiring personal knowledge about that fact. Or, so yeah, basically, you can get, if I testify about my birth date, I don't personally know from personal knowledge, you know. I was kind of there, but not aware of it. But I can testify what my birthday is. So let's see. Well, so that I guess this is more important: authenticating or identifying evidence. So evidence about public records, evidence that a document was recorded or filed in a public office as authorized by law, or a purported public record or statements is from the office where the items of this kind are kept. So that would be something that the, the this is the problem with recording late at night, is that's when brain farts happen. But the custodian of records. The custodian of records can authenticate. Yes, this is the body camera footage that I downloaded off of Sergeant Tory's body camera. I archived it in the normal manner and practice of the LVMPD and provided the unedited copy. And he'd make the same declaration. But you don't have to go to the custodian of records if you have the officer who made the recording. The officer who made the recording, in fact, is the best person to authenticate it. And Delete Lawz, affiants don't testify who produced the documents. He does. He does. I can confirm that it is a true, accurate, and complete copy of what my body-worn camera captured on the day of the incident. That's who produced the document. And the videos that they made were incomplete and are indicative of a credibility problem that calls the completeness of these videos into question. It's possible that it contains parts of this action, but it's unlikely they're unedited or show anything relevant, blah, blah, blah. Except for his sworn declaration that it's a true, accurate, and complete copy of the body-worn camera. It has not been modified, edited, or otherwise changed. And he has reviewed it. And we have the same from each of the officers on scene. So he's just wrong. He's wrong. He's wrong. It's, I don't know how to say it any plainer than that. Delete Lawz is wrong. He does not know what he's talking about. He needs to stop. But then his next complaint, evidence submitted outside of the four corners of the complaint. Since the defendants offer evidence attached to a motion to dismiss, it should be disregarded as improper and should be stricken. A court may look only at the face of the complaint to decide on a motion to dismiss. Van Buskirk versus Cable News Network, 9th Circuit, 2002. Just because plaintiff mentions that body cam footage may offer evidence of further illegal behavior by defendants doesn't make all body cam footage in defendant's possession referenced in the complaint. Further, plaintiff disputes the authenticity of the videos. Even where plaintiff referenced these videos and the authenticity was not in dispute, this court would still have the discretion and would not be required to incorporate the videos. Davis versus HSBC Bank, Nevada. And that's 9th Circuit, 2012. So let's just say he did mention it. Let's where Second amended complaint. I have a feeling we're going to have too many hits on this. 21 video. Okay. Plaintiff's video. The video of the incident shows Bork ask plaintiff if he is on drugs. It doesn't say plaintiff's video. It says the video. The video. That's vague. That's inclusive. Video shows. Which video? All the videos of the incident. So the facts in the incident report contradict the video and were either fabricated or merely pretextual. Once again, it doesn't say plaintiff's video, which the video evidence disputes. Once again, which video? Indeed, as shown on the video footage captured by plaintiff's cell phone and the video footage plaintiff expects to obtain from defendant's body cams. So you bring in their body cams right there, based on your video and the video you expect they have. And so individual defendants submitted police reports that contradict the video evidence. Once again, which video? So there's only one specific reference to his video. Every other reference, there's one specific reference to his video, one specific reference to body cam video. Every other reference is just to video, generic video. If you don't plead with specificity, you're going to have problems. What kind of problems? Vagueness problems. And then the first several I was going through were about like the training videos and stuff. So those are the ones we skipped. So once again, He doesn't understand what he's talking about. But his next complaint, conversion to a motion for summary judgment. Since the motion is not clear on where the motion for dismissal is separated from the motion for summary judgment, plaintiff will look to this court to give its express notice of its intent to convert the motion from a 12b6 motion, even though defendants have already filed an answer. Federal Rule of Civil Procedure 12D. Well, no, they haven't filed an answer. They have not answered this complaint. Their answer is Kaputsky. It's gone. It does not exist because you filed an amended complaint. They haven't answered. We discussed that ad nauseum. But court, tell me, are you going to consider it? It was pled in the alternative. He does not understand, even though this motion was brought in the alternative. He does not understand pleading in the alternative. The court is not going to give you guidance. You have to respond as if you're responding to both a motion to dismiss and a summary judgment motion. Respond to both as to each and every claim to be safe. Otherwise, you're going to have a bad time. The court does not have to give you guidance. It would be inappropriate for the court to give you guidance. Hire a lawyer. And once again, a 12b6 motion is improper where a party has filed an answer. A motion making a 12b6 defense shall be made before pleading if a further pleading is permitted. Federal Rule of Civil Procedure 12b. Here, defendants have filed an answer, and so motion should be stricken as improper. But once again, they haven't. That you brought an amended complaint. That supersedes everything else. It's like the lawsuit started over. Except for the fact that, there are things that were dismissed with prejudice that you brought again, and those need to be stricken. And he says, motion to strike appropriate. The court may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. Federal Rule of Civil Procedure 12F. And, well, the only thing redundant, immaterial, impertinent, or scandalous is Delete Lawz bringing claims that were dismissed with prejudice. He needs to stop. And I declare under penalty of perjury that the foregoing is true and correct. December 22nd, 2023, Jose de Castro, pro se plaintiff. And I mean, no. He had a certificate of service on that one. Apparently, if it's Christmas, you don't need a certificate of service. You just need a declaration under penalty of perjury, which isn't actually required. So, next up, like I mentioned, we're going to discuss the motion to compel discovery, because Delete Lawz doesn't understand discovery and the obligations of discovery, and he wants everything, and he wants immaterial things. He's gone fishing, basically. So, and once again, 1258 Franklin Street, Santa Monica. I'm not doxing you. I'm just saying that's on the caption of this public document, public court filing, because it's relevant to the discussion So motion to compel discovery responses. And basically, I'm going to go over part of this document, but most of what I'm going to go over is going to be in the response, because it makes more sense than going through the same thing twice when I can just go with the responses. So we'll do it that way. So pursuant to Federal Rule of Civil Procedure, Rule 37, and Local Rule 26, Plaintiff Jose de Castro respectfully moves this court to compel discovery responses from all defendants. Pursuant to Local Rule 26-6C, plaintiff has made a good faith effort to meet and confer as defined in Local Rule IA 1 to 3 F before filing this motion. Memorandum of Points and Authorities. The discovery sought by plaintiffs is relevant to plaintiffs' claims or defenses. The discovery sought is proportional to the needs of the case. No, it's not. Especially considering the importance of the issues at stake in the action, the amount in controversy, the parties' relative access to relevant information, the parties' resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefits. Defendants have not objected to any of plaintiffs' discovery requests, and the time limit to do so has expired. That's just a flat out lie. They have objected, as we will see. Plaintiff sent the attached request for production of documents, but has not received any responses. Once again, false. Plaintiff requests that this court order defendants to compel discovery for plaintiff's first request for production of documents. Once again, they have. You just don't like what they produced. That doesn't mean you get to lie about it. I seriously think at this point he needs sanctions. Just the blatant falsehoods in this document. He should be sanctioned. He's full of it. As the English would say, he's been telling porkies. So certification of meet and confer requirements. I attempted to meet and confer and discuss a proposed extension of time to respond, but defendant's counsel, Craig Anderson, has been generally unavailable when I call his office, or when I get him on his cell phone, he says he sent it and changes the subject and otherwise fails to respond. So basically, you're complaining that he doesn't make himself available to you at all times and all hours. That's why you email. But when I do get him on the phone, so he doesn't answer, but when he does answer, he says he has already sent the response. And then he changes the subject and doesn't respond again. So what you're saying is, when I am able to get a hold of him, he says he responded, which he did. Prior to the response due date, Anderson did confirm receiving the requests for production and even confirmed the due date of December 16th in 2 separate emails. I called defense counsel at the following times: December 18th, December 21st, 3 times, and December 22nd, 2 times. I've even texted Anderson back and forth. When I repeat to him that I've not received the discovery and ask if he wants to agree to a new due date, he just says that they already sent it and sends me another copy of defendant's initial disclosures. I've now received initial disclosures 10 times and keep telling him that it's not what I'm referring to. He seems to be playing games. Dated December 22nd, 2023. Respectfully submitted, Jose de Castro, pro se plaintiff. Now, he has sent them 10 times. Delete Lawz just doesn't like what he's received. That doesn't change the fact that they have been sent. He just doesn't, like, he's either recalcitrant, doesn't understand, or is upset by what he received. But he received responses. So attachment 1 is his first request for production of documents, and don't worry, I'm speeding through this because we'll see the actual responses. But just like, request for production 1, all communications between you and any other defendant. Plaintiff will be adding claims for conspiracy to the amended complaint. So basically that's what we have, speeding through it. And it was sent November 16th, 2023. But we have here filed today the defendant's response to that. So defendant's opposition to plaintiff's motion to compel discovery. And defendants, Las Vegas Metropolitan Police Department, LVMPD, and the officers, by and through their attorneys of record, Markey Auerbach, hereby file their opposition to plaintiff's motion to compel discovery. This opposition is made and based upon the attached memorandum of points and authorities, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of hearing. So, memorandum of points and authorities. Introduction. Plaintiff's motion to compel is misleading and a waste of judicial resources. But tell us what you really think, Craig Anderson. When Craig Anderson says this motion to compel is misleading, what he's really saying there is Delete Lawz is full of it. He is lying. It's untrue. Craig Anderson is saying it slightly more politely. It's misleading. In the motion, plaintiff claims the defendants failed to respond to his requests to produce. In truth, defendants timely mailed their responses to plaintiff's address. And when plaintiff contacted defense counsel claiming he had yet to receive the discovery, defense counsel, while on the phone with plaintiff, emailed him the responses with a Dropbox link. Thus, the discovery requests or responses have been both mailed and emailed to plaintiff. Statement of facts, we don't need to do that because we've already gone through the statement of facts multiple times. It's just the story about the traffic stop. So, relevant procedural history. On November 16th, 2023, plaintiff improperly served the defendants with his first request for production of documents. On December 18th, 2023, defendants properly served their responses to plaintiff's first request for production of documents, Exhibit A, which we'll see in a minute. Concurrent with the responses, defendants also served plaintiff with their first supplemental disclosure of witnesses and documents, Exhibit B. Both pleadings were mailed to the following address: the Sahara Avenue address in Las Vegas. Even though, as of his last filing, he still lists Santa Monica, California, even after his change of address. I think he is the one playing games. On December 15th, 2023, plaintiff identified this address in his notice of change of address with the court. The defendants provided plaintiff a Dropbox link for documents and videos referenced in their discovery responses. The Dropbox Dropbox link remains valid through January 18th, 2024. On December 21st, 2023, plaintiff called defense counsel requesting the status of the written discovery responses. Defense counsel informed plaintiff that the responses and supplement had been timely mailed to his preferred address. Plaintiff claimed he was having difficulty receiving his mail due to a roommate issue. Is he having a roommate issue at the UPS store? Or is the roommate issue in Santa Monica, California with David Condon? Or is that Jeff freaking Lloyd? In response, defense counsel, while still on the phone with plaintiff, created a new Dropbox link and immediately emailed it to plaintiff's email address. And once again, before I get too much further, his roommate issue, once again, even if there are roommate issues that have stopped him from receiving the responses, that's not Craig Anderson's problem. He fulfilled his duty. But he fulfilled his obligations. He sent it to your address that you have on file. If you have problems on the other end, that's your fault. That's your fault. Plaintiff now claims that this link was defendant's initial disclosures and that defense counsel seems to be playing games. Defense counsel has verified that the December 21st, 2023 link was, in fact, the documents responsive to plaintiff's requests for production. Legal standard. Plaintiff alleges that he is entitled to sanctions pursuant to Federal Rule of Civil Procedure 37. Rule 37 governs the failure of a party to make disclosures or the failure of a party to cooperate in discovery. As set forth and in the attached exhibits, defendants timely and properly responded to plaintiff's request for production of documents. The documents were timely disclosed in proper form, and the Dropbox link for plaintiff to access the documents has been provided on 2 separate occasions and is still active. It appears that plaintiff does not know how to properly interpret the defendant's discovery responses and their first supplement to disclosure statement. An alternative explanation is plaintiff is intentionally misleading this court because he failed to timely file an opposition to defendant's motion to dismiss. CEG ECF number 71. What was 71? The motion to dismiss. Regardless, plaintiff's motion to compel must be denied. Let me translate that into plain English. It appears that plaintiff is a moron, or he's lying because he wants more time to respond to the motion to dismiss, which is late. But why not both? He's a moron and he's salty because he needs more time. I like that better. But conclusion. Based on the above, defendants request that plaintiff's motion to compel be dismissed. Dated this 28th day of December 2023 by Craig R. Anderson, Markey Auerbach. And it was mailed, certificate of service, to the Sahara Avenue address. So Exhibit A is the discovery response. So this is what was sent to Delete Lawz. Defendants, LVMPD, and the officers' response to plaintiff's first request for production of documents. So generally, we wouldn't get to see this. That this is not done on the record. This isn't part of the docket. We just get to see it because Delete Lawz is a moron and made it an issue, so it had to be included as an exhibit. And I'm not saying anyone should click on it, but the Dropbox link is also public. I don't know if it's password protected or not. I'm not clicking on it. I wouldn't suggest you do, but just saying it's there. So pursuant to FRCP Rule 37, defendants, LVMPD, and the officers, by and through their attorneys of record, Markey Auerbach, hereby respond to plaintiff's first set of requests for production of documents. Request number 1. All communications between you and any other defendant. Plaintiff will be adding claims for conspiracy to the amended complaint. Response. Objection. Remember when Delete Lawz lied and said they didn't file objections in time? That is your objection. That's your objection. Objection. The term all communications is vague and ambiguous and overbroad. Notwithstanding this objection, each individual defendant has searched all paper files of their unit, their computer, and their work cell phones, and found no unprivileged documents responsive to this request. Any responsive emails are covered by the attorney-client privilege. So, any communications between you and any other defendant, that's way overbroad. Way overbroad. Police officers talk to each other. They're in the same unit. They're in the same precinct. They're going to talk to each other. Like any communications between you and another defendant about plaintiff, that probably wouldn't be objected to. But you're not as important as you think you are. So they're not going home for weeks after and emailing each other. Haha, remember when you hit him in the nuts? That was funny. They went home and they forgot about you. They didn't give you another thought once you were out of their sight. You are insignificant to them. Insignificant. I realize that for Delete Lawz, that is the worst thing to be, is insignificant. But he is. So, request number 2. All communications between you and any person associated with the LVMPD, Las Vegas Police Protective Association. Sorry. And once again, objection. The term all communications is vague and ambiguous and overbroad. Notwithstanding this objection, each individual defendant has searched all paper files of their unit, their computer, and their work cell phones and found no unprivileged documents responsive to this request. Any responsive emails are covered by the attorney-client privilege. So, Delete Lawz hates this, but this is a response. It's a response. It's not the response he wanted, but it's a response. Now, he could bring a motion saying, Judge, make them respond to request number 2 specifically. I believe they have unprivileged documents in there that I am entitled to. My reason for that belief is this. but just going, Your Honor, I think there's something there and they're not giving it to me. And so make them give me all my requests. That's not within the rules. So request number 3, all communications concerning plaintiff or his associates, including Floyd Wallace, between you and any other person, including but not limited to family members and colleagues. Response: objection. The term all communications is vague and ambiguous and overbroad. Notwithstanding this objection, each individual defendant has searched all paper files of their unit, their computer, and their work cell phones and found no unprivileged documents responsive to this request. Any responsive emails are covered by attorney-client privilege. Besides which, why would they know? I mean, Craig Anderson knows you're an associate of Floyd Wallace, but why would the officers know you're an associate of Floyd Wallace? How would they know who any of your associates are? You were alone. I mean, the only associates they know of yours are Charlie, hashtag free Charlie, and your nephew, who came to collect the van and Charlie. Request number 4, all documents and things that would show any current or past organizational structure between each defendant. He's fishing. He's trying to build the RICO case when he has absolutely no evidence of RICO. None. He has his conclusory statement in the complaint. It's RICO. Trust me, bro. And so he's trying to find it, but as we've discussed in the past, you can't just bring a lawsuit. It's not ready, fire, aim. It's ready, aim, fire. You have to have something there to survive a motion to dismiss. And he has nothing. He's hoping to find it in discovery. But number 1, there's nothing to be had. And number 2, you can't go fishing for it even if it were there. You have to have a good faith belief, a good faith request, period. It just doesn't work. So response to request 4, objection. This request is vague, ambiguous, and not reasonably calculated to lead to admissible evidence. Further, the request is not limited to time or identify the specific organization structure that is allegedly between each defendant. As such, defendants cannot respond to this request in its current form. Request 5. All documents and things that would identify the true name, address, and phone number of each defendant. You don't need that because, for starters, all communication should be with their attorney, Craig Anderson. So the only reason I can think of for him requesting this is to harass them, to send his supporters, to send his minions, to send the army of dumbasses to picket and protest at their house and to harass them. And that's illegal. But the response: objection. This request seeks information that is confidential pursuant to Nevada Revised Statute 289.025. All served defendants can be reached through their counsel of record. So it's even protected by state law, but Delete Lawz is a moron. He doesn't understand law. Request 6. All documents and things concerning disparagement of plaintiff and his associates. Response. Objection. The term disparagement of plaintiff is vague and ambiguous and subject to differing interpretation. Further, the request makes no attempt to identify plaintiff's associates. Despite these objections, none of the defendants have any documents responsive to this request. Once again, they didn't defame you. They forgot about you. They don't care about you. You were not the memorable person that week. They do this for a living. They deal with criminals. They deal with dumbasses. They deal with drunks. They're Las Vegas police officers. Like, of their memorable arrests, you don't rank. You're so far from ranking that you're insignificant. So, request 7. All documents and things concerning the location, tracking of location of plaintiff or his associates. And response, hey, no objection. The response is simply, no defendant has any documents responsive to this request. So, Delete Lawz, they didn't give me what I want. And it's like, we don't have it. Nothing exists. You can't get blood from a stone. You can't get documents about tracking him when they don't exist because no one's been tracking him. The reason he had subsequent interactions with police officers is because he was the one tracking them. He was the one on the hunt for cherries and berries. Dumbass. Number 8. All documents and things concerning the facts or reputation of plaintiff or his trade. Response, objection. This request is vague and ambiguous and subject to differing interpretation. Despite these objections, none of the defendants have any documents responsive to this request. Number 9. Number 9. Number 9. Sorry. The White Album is great with one exception. All documents and things concerning harassment, trolling, vandalism, hacking, or social media post, or any other behavior concerning plaintiff or his trade. Objection. This request is vague and ambiguous and subject to differing interpretation. Despite these objections, none of the defendants have any documents responsive to this request. Number 10. Copy of any and all recorded interviews and respective transcripts conducted in connection with this action. Response. No recorded interviews occurred in connection with this action. This wasn't a notorious crime. Why would they be giving interviews? You don't matter. He really does have delusions of grandeur. And he thinks this is the crime of the century, as opposed to Tuesday for the officers. So, number 11. Name, address, phone number, and email address of any witness, any of the witnesses that each defendant intends to call at trial. Response. Please see Defendant's Rule 26 disclosure list of witnesses. So we already gave you our list of witnesses that we intend to call. They were in our initial disclosures. You have those. Number 10. And I really hope that the driver of the Hyundai Elantra isn't included, because I don't want her being harassed by this numbskull. So, number 12, name, address, phone number, and email address of all witnesses of the arrest and concerning incidents to the arrest in this action, including but not limited to officers and supervisors at the scene, dispatchers, and the passengers of the silver Hyundai Elantra that Bork was interacting with on March 15th, 2023 related to this action. And the response, please see Defendants Rule 26, Disclosure of Witnesses. Number 13, copy of any and all crime scene analysis and or forensic reports, results, requests for examination, and or testing performed on any of the physical or biological evidence collected concerning this action, specifically but not limited to the results of any testing involving blood, DNA, hair, fingerprints, shoe prints, or any or other samples taken, and information of evidence gathered but not tested in this action. Like I said, he thinks this is the crime of the century. But guess what? Guess what? They didn't do any forensics. They didn't collect blood. Why? There wasn't any. They didn't do any recreations. Why? They didn't have to. It's entirely captured on body camera. Entirely captured on camera. It's the entirety of the testimony or the entirety of the evidence can be provided by eyewitness testimony from the officers and their corroborating body camera evidence. That's all that's needed. They don't need to draw up diagrams. They don't need to have a medical examiner or a crime scene expert. This isn't a murder. This isn't anything. This is obstruction. This is delusions of grandeur. So, response, objection. This request is harassing as plaintiff knows that no responsive documents exist. All documents related to plaintiff's arrest were produced in Defendants Rule 26 disclosure. Number 14. Copy of any and all audio recordings and related documentation, including but not limited to 911 calls, CAD-to-CAD, dispatch calls, communication logs, and any otherwise memorialized communications concerning this action, including but not limited to any communications where officers discuss First Amendment auditors, the recording of police, this action, incidents including leading up to this action and after the alleged incident concerning this action, the plaintiff or his associates. Response, please see Exhibit 16 provided in LVMPD's first supplemental disclosure of witnesses and documents. It is also provided on the following Dropbox link right there and is available for download until January 18th, 2024. Request number 15. Copy of any and all photographs taken and or gathered, crime scene diagrams drafted, and investigative reports prepared by law enforcement in connection with this action, including but not limited to property inventory reports, impound reports, and images of the scene concerning any alleged incident concerning this action. Response, there are no documents responsive to this request beyond the documents produced in Defendants Rule 26 disclosures. Number 16, disclosures of any and all details of any compensation, express or implies promises of favorable treatment or leniency or any other benefit that any of the state's witnesses received or expect to receive in exchange for their cooperation with the concerning prosecution or litigation, including but not limited to any promise made to any witness to provide monetary support, counseling, and or treatment. And, you know, witnesses can be paid. Expert witnesses are paid a lot of money. Generally, lay witnesses shouldn't be paid, but they might receive basically they might receive compensation to offset their losses for testifying. So if they have to take off work for 3 days to go testify, that in some jurisdictions there might be laws saying, yeah, you can't compel them to miss work unless you compensate them for it. And if they have to travel, you reimburse their travel expenses. But in this case, well, number one, that as well, let's look at the objection first, the response. Objection. This request appears to be drafted in response to plaintiff's criminal case. The defendants do not have any documents responsive to this request. So we're going to see a lot of that. Objection. This isn't the criminal case. But it's like, in this case, the compensation they receive is their salary. They're on the clock when they testify. Period. Request number 17. Copy of any and all written statements, reports, and/or information provided by the alleged victims. Response. Objection. Plaintiff claims he is the victim in this case. Therefore, any responsive documents are in plaintiff's possession. He claims to be the victim, so he has all the statements he made. We don't. The person to go after is yourself. Discovery is not masturbation. Well, it's not a hand job. You should self-satisfy. Let's put it that way. Request number 18. Copy of any and all video and/or audio recordings of the alleged incident and/or otherwise related to the allegations in this case, including but not limited to body camera video recordings, including but not limited to any communications where officers discuss First Amendment auditors, the recording of police, this action, incidents including and leading up to this action, and after the alleged incident concerning this action, the plaintiff or his associates. Response. Please see body-worn camera footage produced in Defendants Rule 26 disclosures. Number 19, complete criminal histories of all state witnesses. Response. Objection. This request appears to be drafted in response to plaintiff's criminal case. The defendants do not have any documents responsive to this request. And Delete Lawz seems to think that he gets that Brady material is relevant, but this isn't his criminal case. Brady is a criminal ruling. Request number 20. Any and all information bearing on the truthfulness or bad character of the state witnesses, including but not limited to any contempt citations issued against the witnesses, any past instances of dishonesty, fraud, lying, or violence on the part of the witness that is known to the state or its agents. And that's basically Brady material. Response. Objection. This request appears to be drafted in response to plaintiff's criminal case. The defendants do not have any documents responsive to this request. 21. Any and all documents made by any state witness or any other persons or any other person that are in any manner inconsistent with the written and or recorded statements previously provided to the plaintiff. Response. Objection. This request appears to be drafted in response to plaintiff's criminal case. The defendants do not have any documents responsive to this request. Number 22. Any documents, including but not limited to copies of emails, texts, memorandums involving any law enforcement officer or other state personnel in which the plaintiff is mentioned by name or reference. Response. Objection. This request is unduly burdensome, overly broad, and fishing expedition. All of the defendants have reviewed their cell phones and computers and found no documents responsive to this request. Number 23. any and all personnel discipline documents for any law enforcement officer or other state personnel involved in this action, including any past or prior discipline or reprimand for said officer's actions which were alleged or found to have violated the civil rights or liberties of other individuals. Once again, this looks like Brady material. And the response, objection. This request is overbroad, unduly burdensome, and violates unspecified individuals' privacy rights. Specifically, the request for any law enforcement officer or other state personnel is overbroad and unspecific and involves individuals these defendants have no control over. Notwithstanding this objection, none of the named defendants has ever been found to have violated the civil rights or liberties of a citizen. So basically, that objection is, look, he's requesting, does any information regarding the mayor, the governor, the attorney general, the dog catcher, anyone that has violated rights. And it's like, but that's not relevant. They're not defendants. They're not involved. We don't have access to their records. How could we possibly respond to this? Number 24. Any materials, written or otherwise recorded, relating to training any officers involved in the underlying case have received training said officers about the First Amendment, the rights of citizens to film officers, and the relation between the First Amendment and obstruction of an officer's duties, including any policy manuals provided to any officer in this case which addresses those issues. And response, see LVMPD training produced as LVMPD 71 through 1321. So it's already been produced. This is just cumulative. Number 25. A list of any remedial or other training concerning the incidents of the case, as well as the contents of that training provided to the officers involved in this case, or the rest of the department concerning or as a result of this case, or where the contents of the training is related to the type of incident in this case. Response, no remedial training has occurred as a result of this case. And why would they give remedial training? The officers did nothing wrong. Number 26. Any of the department's use of force, arrest, misdemeanor arrest, and interactions with the public policies, including any policies on dealing with the media, press, the freedom of speech, and recording police, including any memos related to any of this that were in effect during the time of the arrest or that were enacted or distributed after. Response. See what's already, been produced. See LVMPD 32 through 70. It's already there. Request number 27. Any document, photograph, or other paper that the party intends to introduce at trial. And once again, response, please see Defendants Rule 26 disclosures. Number 28. Any exculpatory evidence that could help the plaintiff. The obvious response, because this isn't a criminal case. Objection. This request appears to be drafted in response to plaintiff's criminal case. The defendants do not have any documents responsive to this request. There is no exculpatory evidence. That's for your criminal case, in which case there also isn't any exculpatory evidence because you're guilty. Number 29, all non-privileged documents and things concerning this action. Response, see the Rule 26 disclosures. Request number 30, all non-privileged documents that defendant sent to or received from any person concerning this action. Once again, see Rule 26 disclosures. Request number 31, all non-privileged communications concerning plaintiff or this action. That's overbroad. But once again, see Defendants Rule 26 disclosures. Request 32, all documents including body-worn camera video, audio recordings, dashcam video, interview recordings, internal security audio and video, external security audio, and video that include each defendant for the entire date of March 15th, 2023. Objection! This request is overbroad and unduly burdensome and seeks information unrelated to the subject incident. Further, the request seeks information that invades non-party privacy rights. Because why? Why would the rest of the day be relevant? Why would you need anything about their previous traffic stops? You're not going to be able to establish a pattern and practice of violating rights. You just want to abuse and take up their time and resources in responding. That's the only reason. Number 33. All documents related to insurance policies that may cover liability concerning this action, or that was expected to cover liability concerning this action. And the response, see LVMPD 71 through 1321, which is they're self-insured. So no insurance. And so signed Craig Anderson, 18th of December. So when Delete Lawz says they didn't respond, they just sent me the initial disclosures 10 times, he's lying. That was the response. Compared to Exhibit B, which, scrolling down, so, no. Exhibit B isn't their initial disclosures. It's the first supplemental disclosure of witnesses and documents. So we're not going to go through all of this, but you'll see we have witnesses, LVMPD, and this, so to Officer Torrey. Officer Torrey is expected to testify regarding the facts and circumstances surrounding the allegations in plaintiff's complaint and any other matters relied upon at the time of arbitration or trial. And all of these, Officer Bork, care of Marky Auerbach, and what he's testifying about. And all of the officers. Doesn't have the driver of the Hyundai. It doesn't have Officer Sitco or Sitgo or Cisco or whatever other variation of the person he added that wasn't even there that day, but had an interaction with him in the past and didn't arrest him. But whatever. So finally, I think this is really going to annoy Delete Lawz, but Magistrate Judge Yucha, or Yuga, however you pronounce her name, has already ruled. And I really think this is going to annoy Delete Lawz because, as we know, he must have the last word on anything. In this case, she ruled the same day that that LVMPD filed their objection. You'll notice December 28th, response to the motion to compel. December 28th, order denying the motion to compel. No time for a reply. It was bing, bang, boom, done. What I mean, I can almost guarantee that when Delete Lawz saw this, he was raging. I'm sure something to the effect of, how dare that bitch rule before I get a reply. I bet something like that came out of his mouth. Or how dare Judge Sugar Tits do this to me? Doesn't she know who I am? In fact, I'm expecting a document similar to what he filed in Massachusetts, asking for all that inappropriate information from Judge Sugar Tits in Massachusetts. He's going to be asking Judge Sugar Tits in Las Vegas for, because he, I'm sure, is raging. He is hopping mad. And I know a thing or two about being hopping mad, believe me. But he, like, I wouldn't be surprised to see a motion to recuse because of this, because he is not going to be happy. But let's look at the order, then we'll be done. So, pending before the court is plaintiff's motion to compel discovery responses. The court has considered plaintiff's motion along with defendant's opposition. Because plaintiff's motion is based on defendant's alleged failure to provide any responses to his request for production, but the object evidence shows responses were provided on December 18th, 2023, the court issues this order before receiving plaintiff's reply. And boy, is he going to be mad about it. And footnote 1, the court notes defendants also provided plaintiff a Dropbox link to documents and videos referenced in their responses on December 21st, 2023. When a party receives requests for production of documents propounded under Federal Rule of Civil Procedure 34 fails to respond to those requests, the propounding party may move for an order compelling production. That's Rule 37A3B4. Under U.S. District Court for Nevada Local Rule 26-6B, all motions to compel discovery must set forth in full the text of the discovery originally sought and any response to it. Defendants unequivocally demonstrate they responded to all of plaintiff's requests for production. Plaintiff fails to acknowledge this fact and instead asserts he received no response from defendants except repeated reference to defendants' initial disclosures. In light of the objective evidence demonstrating defendants responded to plaintiff's RFPs, plaintiff's argument in favor of compelling responses to his RFPs lack merit. Moreover, plaintiff's general assertion of no responses, rather than identification of those responses by defendants he disputes as insufficient, fails to satisfy plaintiff's Rule 37 burden. And that's Tran versus Young, Eastern District of California, 2020, which ruled the party seeking to compel discovery responses must inform the court, 1, which discovery requests are the subject of the motion to compel, 2, which of the responses are disputed, 3, why the party believes the response is deficient, 4, why any objections are not justified, and 5, why the information sought through discovery is relevant to the prosecution of this action. To the extent plaintiff is concerned defendants are in possession of additional documents responsive to his requests, plaintiff must articulate something more than a suspicion to support his concern. So Captain Conclusory can't be Sergeant Suspicious either. And that was Volus versus Kingsbury Condominium Owners Association, Central District of California, 2014, which says, plaintiff's mere suspicion that additional documents exist is an insufficient basis to grant a motion to compel. Rather, the moving party must have a colorable basis for its belief that relevant, responsive documents exist and are being improperly withheld. For each and all of the reasons set forth above, it is hereby ordered that plaintiff's motion to compel discovery responses is denied. Dated this 28th day of December 2023 and signed by Elena J. Ucha, United States Magistrate Judge. So that was a fun one. Like I said, I bet Delete Lawz is mad as he's furiously, frantically, belatedly typing up his appellate brief for the Ironton case. He's going to lose that too. He's going to lose this. I mean, I really I look forward to Craig Anderson's response. Just the response to the motion to compel, or sorry, the response to I'm going brain dead. I'm motion to strike, that one. His response to the motion to strike or for an extension of time should be fun. I look forward to it. Its response is due by January 5th. Even, I doubt Craig Anderson's going to, but Judge, New Year's is in the way. How do you expect me to respond in time? So, yeah. Either way, this was a fun one. Thank you for joining me. I will see you in the next one, which might be for that. It might be, hopefully, we should get more in the Lauren the Mortician stuff. For those of you who haven't watched it, that one's fun. It's going to be a fun case to follow. We've only done the complaint so far, but I need to do a video reviewing some of the background stuff surrounding it, because that's going to be a train wreck. So either way, thanks for joining me. Please do all the YouTube-y things, like, share, subscribe, bribe your friends and family to do the same, and I will see you soon for the next one. Bye-bye.